Good afternoon, Your Honors. Attorney Adam Zanitas for the appellant, Ms. Karuna Chaudhary. I'd like to reserve 3 minutes for reply.
3 minutes, okay.
Yes, Your Honor. Just a very quick background. This is a post-divorce matter out of Williamson County. As of today, they have 2 minor children, Amber, age 15, Gwen, age 12. The parties were originally divorced on March 1st, 2017. At the time of the divorce, mother was awarded 213 days compared to father's 152. Mother was the primary residential parent at that time. In other words, dad had 5 out of every 14 days during the school year, and it was week on, week off during the summer. At the time the parties were divorced, the mother had sole decision-making for non-emergency health care, school zoning, and otherwise they had joint decision-making, although the original parenting plan was silent as to religious upbringing and who had the decision-making there. Fast forward to March of 2022, so about 5 years after the original divorce was entered, mother filed a motion to approve a counselor for the children, so Amber and Gwen. Shortly thereafter, she filed a petition to modify the parenting plan, and then father filed his response in a counter petition to modify the parenting plan. Trial occurred in this matter in 2024 after about 2 years of litigation. At trial, the judge found, this is another Judge Johnson case, she found that custody should be changed as to both children, and she awarded the parties 50-50 parenting time. So father became the primary residential parent. There were a couple of post-divorce motions that were filed, and I'll address those if we have time to get to it. My client has raised a variety of issues for appeal. I'm going to try to hit the ones that are most important first. She is challenging the trial court's determination to change custody and to award the father 50-50 parenting time. So the standard here is essentially, the case I like to cite is Maupin versus Maupin, and we have to consider whether or not the evidence preponderates against the trial court's findings of fact upon which it based its determination. Further, if the evidence preponderates against the trial court's findings of fact and focuses on facts, which it should not really matter, while ignoring those that really do matter, the court may be found to have abused its discretion. So I think it's important in this case to highlight several instances regarding both the custody and parenting plan modification where the facts proved do not match the court's findings. And I've highlighted these.
Are you suggesting that there is no material change of circumstance?
Your Honor, I am, at least as to the minor child Gwen. And I spent a lot of time in this brief kind of highlighting that the trial court didn't really differentiate between these children. And the best interest standard is you're supposed to determine the best interest of the child. It doesn't say children, it doesn't say child, parentheses, REN, it says child. And I'm not saying the trial court's required to go through every factor as to each child and the separate findings. They can address both children within the findings.
There is a preference to keep siblings together.
There absolutely is, and I've brought that case that I cited in the brief. It's Height versus Height. This is actually a fairly recent case from 2004. This is from the Court of Appeals at Jackson. And the standard here is pretty straightforward. I mean, it says that, generally speaking, Tennessee courts have held that it is not appropriate to separate siblings by custody order. However, there is a presumption against separating siblings. This principle must give way to other considerations if it's in the best interest of a child to do so. The court has, upheld several cases where children have been on different schedules. This case also says that it's well established that the preference for siblings to remain together is not a controlling factor. So I think that, yes, we would love to keep these kids together, but my client's stance.
Well, I mean, I would agree with you that the courts seem to focus on the relationship between mother and older child, but it does lead off by saying the severe dysfunction in this family and the terrible relationship between mother and, when I say older child rather than mentioning the children's name. But so it sounds like the court is worried about dysfunction generally when mother has both girls.
Yes, Your Honor, and I think that's important that you pointed that out.
And granted, it sounds like maybe the older child might be contributing to the problems with relationship with the younger sibling, but still, I mean, if there's dysfunction there, can't that raise to the level of a material change?
It can raise to the level of material change. But as to Gwen, then you still have to walk through the best interest factors and find that the things that have occurred make it so necessary that mother's time should be reduced and father should be increased. But those facts just weren't here. I mean, both these kids were doing excellent in school. They were doing very well. They had good social lives. Judge Johnson said it herself, especially as to the older child, you know, every other aspect of her life is perfect except for her relationship with her mom. And again, it seems like the court's already aware of this, but there is just not a lot of discussion about the younger child in this opinion.
Well, the discussion about the younger child dealt with mother misrepresenting what the COVID shot was.
Correct.
And maybe another instance or two that seemed to undermine the relationship. And I got a sense, maybe this is wrong, and you correct me, that the court was concerned that she was starting to travel down the same road with Gwen that she traveled with Amber.
I don't think the court ever says that, and maybe
I don't
it's
think the
insinuated.
court said that,
Right.
but that was the sense I got.
Maybe that's insinuated, but if I can just touch on the COVID shot, it was such a huge part of this case. We have to remember this is 2022. It's a completely different time. It's 3 years later now, but this is 2022 when my client decides that this child should be vaccinated. I don't think the trial court gave her any credit for the fact that she had sole decision making in this category. And for all these decisions, she, on her own fruition, did discuss it with the father, even though she didn't have to. One time in 5 years, she decides, I'm going to use this power to make a sole decision, and I'm going to go and get the younger child vaccinated. And the older child has been so ingrained with the COVID shot being bad that she threatens suicide. She puts a knife to her throat the moment she finds out about it.
Yeah, we've read the briefs.
Okay. So, to me, the trial court not making a finding that father's discussions with the older child and text messages and sending her articles and videos about how people die from COVID shots, about how women can't have children if they have the COVID shot, for the trial court not to find that influenced the child. I don't think any trier of fact should have made that finding. They should have found this was a problem, he shouldn't have done it. The issue was brought, I mean, there's kind of two different judges in this case. It was originally in front of Judge Smith in Davidson County and then transferred to Williamson. I mean, Judge Smith, when he heard about this, he put an order in place and said, don't talk about this litigation. And he did have a problem with discussing the COVID vaccine like that. So you kind of have two different outcomes from two different judges. One was pendant light, one is a final order. I think also the credibility findings I had a lot of problems with in this case because Dad did some stuff he shouldn't have done, but that's just not really in the final order. I mean, he is talking to the minor children about litigation. He's telling them what he's found in discovery, i.e. mom reviewed one of the child's diary entries when the child was 11 years old. I don't really think an 11-year-old has a huge expectation of privacy as to their diary, but Judge Johnson treated that as if it was a huge problem that mom did that. What mom found was the suicidal ideations in the diary entry. So I think you have to look at the facts that really matter, i.e. what this diary entry said versus the fact that mom looked at it. So that's why I'm really hammering on that because I just think that's a huge problem. And I don't think the court handled it appropriately, respectfully. Dr. Berryman testified in this matter. She didn't testify at trial, but the parties agreed that her prior testimony would be admitted. Dr. Berryman, you know, she was the sole expert in this case. I mean, she did find that father sending those articles to Amber was problematic. She did find the way that the older child spoke to mother was very problematic. The children didn't want to discuss their father when they were meeting with the
Is
counselor.
there any evidence that Amber did her own independent research regarding the COVID shot?
There is. So Amber testified in this matter for a significant period of time, and she actually makes the statement under oath that she would have come to her conclusions on COVID even if her dad hadn't talked to her about it. So the court heavily relied on this minor child's testimony. At the time she testified, I guess she would have been 14 years old. At the time all this stuff was actually going on, though, with the COVID shot, she was 11 and 12. So another problem here, too, and I put this into our reply brief, but some of the stuff this child was doing to the younger child, confronting her, recording her, telling her you've got to support dad over mom, saying some kind of horrific things to the younger child. I mean, I just find it very hard to believe that the dad wasn't alienating this child to some degree, which I think spilled over to the younger child, older child to younger child. I'll try to stop using their names. I think I really briefly want to touch on some of these other issues. I think that's the most important issue, but the issue with the absolute travel ban for international travel, I mean, there was no discussion really about that in the final memorandum and order. There is a whole section in the Tennessee Code for domestic relations about child abduction prevention orders. There's a whole list of factors you're supposed to consider if you're going to enter an order like this.
So had these children ever traveled outside the country with mother?
Yes, Your Honor. They had traveled to the Bahamas before. No issues with it. But the odd thing in this case, I guess the outcome is neither parent can do it. I mean, neither parent, and there's no path to getting the passports. It's just an absolute ban. I mean, you can't file a motion with the court. You'd have to file a petition to modify, I guess, if anybody wanted to travel. The other thing, again, this is touching on credibility. I'm trying to go fast. The trial court found that mom lied about who her relatives were that lived in India. And mom testified that her mother resided in India and kind of left it at that. She was never asked to list all of your relatives that live in India. But the trial court puts in the final memorandum, mom lied to me about this. She said the only relative she has that lives in India is her mother, but her sister lives there too, because the father testified about that. I just thought it's not in the record. Mom never came in and claimed that she had no relationships whatsoever to India. So the odds of her absconding with these children is extraordinarily low in my opinion. As far as, and just very briefly on attorney fees, the judge ordered my client to pay $30,000. My client prevailed on numerous motions throughout this case. Father did not prevail on his petition for criminal contempt. Father did not prevail on having his parenting plan entered, technically. I mean, there's no holiday parenting time, complete violation of the statute. You are required to do a holiday parenting schedule. The judge elected not to do it. My client hasn't had Mother's Day for the last 2 years.
So what about the point made in the appellee's brief, though, regarding the difficulties because of this faith group's shifting dates for certain holidays? I mean, I guess one way to handle it is just say, whenever that holiday occurs, mother will have, I'm not that...
Holi and Diwali.
Yeah, Diwali, yes, thank you. That holiday, I guess, is one way to handle it.
I think it's easy, and my client suggested, let dad pick 2 of his favorite Christian holidays, let her pick 2 of her favorite Hindu holidays, and then they both get that holiday each year. And both parties propose that they get holiday parenting time in their proposed parenting plan. So it was kind of a surprise when she just decided to do no holiday time, follow the basic plan. Thank you.
Thank you.
May it please the court, my name is Michelle McGill. I represent the appellee, Benjamin Boatman, in this matter. As the court's aware, this is a post-divorce modification where the trial court was asked to address the breakdown in the parenting arrangement that was no longer serving the best interests of the children. The trial court made a detailed opinion with findings of facts and applied the correct legal standards in issuing its ruling, which prioritizes the children's stability, their health, their emotional health, and their long-term well-being. As the court's aware, under Tennessee Appellate Rule number 13D, the findings of the trial court are presumed correct unless the evidence preponderates against them. This is especially important in custody matters where the trial court hears live testimony and evaluates the witness's credibility. Here there was, this trial had hours and hours of witness testimony of both the parties and the party's oldest minor child. The appellate now invites the court to substitute the court's judgment for the trial, for your judgment for the trial courts, but absent clear and convincing evidence to the contrary, the lower court finding must stand. The first issue of the child custody modification was proper. The dysfunction within the family, the court found including emotional manipulation, lack of cooperation, and the deterioration of the parent-child relationship was pervasive. and well documented.
And here, the emotional manipulation was in the form of what?
Well, at trial, we presented multiple recordings by the children and the mom. There was manipulation in the form of, obviously, the mom would say, there were several in a car that I can recall, where the mom would say to them, don't you miss me? Aren't you sad when you're not around, Mom? And that sort of thing. Arguments about having arguments about the medical care, the COVID shot, and that sort of thing.
Yeah, that just seems like, there was a lot of focus on the vaccine. That just seems like an odd topic to worry a 8-year-old?
Well, and
when I was 8, I only cared whether or not I was getting a shot or not. I
Right.
didn't care what it was. I didn't want the shot.
the first thing I'll say about these two girls is that they're extremely intelligent, and they are think way above their age, their actual age. And there's no question that that issue was driven by the older child, that was her concern, and that they were arguing about it openly in front of the younger child, and so she became enmeshed in this argument as well. So as far as the manipulation, that's about what I recall from the trial was the videos that we have of them. And then mom, another thing that the children complained about, particularly the older child, was that they were doing so well in school, but mom was constantly harping on them about their homework, and they couldn't talk to their dad because they needed to do their homework and they needed to study and that sort of thing. And I can't recall, I think the record should reflect all of the incidences of the manipulation that were claimed.
Counsel, there's cases where multiple siblings are involved, where they're experiencing something very similar in terms of a breakdown in the family. Here, it looks like there may be significant differences between the older and younger child, in this case, in terms of relationships. This is a trial court, and it's an extensive decision, but did the trial court really go through and consider these children separately? Or do we have a conclusion that, well, really, with regard to the older child, a change is needed, and so we're going to have the younger child tag along? Is there really an independent determination being made here that this is also in the best interest of the younger child?
I believe that there was quite a bit of consideration about the younger child as well, and I do believe what Your Honors pointed out before, that the court was indicating that it believed the younger child was following along. It was headed that way with the younger child. There was less of it with the younger child, but it seemed to be increasing throughout even the pendency.
Did the court say that, or is that just an inference?
I believe that's an inference, and I believe that that's what the evidence showed. The trial court found that the mother's conduct directly contributed to the children's emotional distress. The recordings that I spoke of demonstrated verbal abuse, coercive tactics, alienating behavior that undermined their children's relationship with their father. The trial court correctly recognized this as a material change after a full analysis of Code 366106A. As far as the suicide that was brought up by the appellant, I believe that the evidence shows that it wasn't that they disregarded this and didn't think it was serious, but no one actually believed that it was apparent that neither parents believed that it was an actual true threat of suicide, but more of an attempt of the older child to get the parents to realize how serious she was about this, and more of a cry for, pay attention to me, I want you to understand that I mean this seriously. And I believe that the court seemed to indicate that she felt that mother was disregarding the child, that this was brought on because the mother was disregarding the child's reasonable feelings and emotional emotional state on this issue, that the mother didn't put enough attention on that. And so that was sort of what brought about this child having to go to that extreme. As far as the decision-making authority, the trial court properly vested father with the decision-making authority regarding education and non-emergency health care due to mother's pattern of unilateral decisions, actions, and concealment. This includes misleading the younger child about the COVID vaccine, lying to her. Her failure to collaborate or seek father's input justified the court's ruling under Tennessee Code 366407C2, which prioritizes the child's welfare over rigid joint decision-making and supports limited decision-making authority for parents when they show an ongoing inability to cooperate, as was shown here. The passport restriction was a cautious and temporary measure rooted in credibility issues. The trial court.
But doesn't it conflict with the statute?
Which statute, Your Honor?
Oh, I don't have the number in front of me, but there's a statute about passports for children.
I'm not sure, Your Honor.
Okay.
I'm not aware of.
Okay, fine. That's all right.
But as neither party currently has a stable plan for international travel that serves the children's best interest, the court acted with its discretion to defer permission until the circumstances.
Counsel, would you agree with regard to the passport travel issue? The trial court didn't make any special findings and didn't make any special findings in accordance with any other statutory provision here. And so there wasn't a process that was followed. So if there's a process provided, specific findings that have to be made under a statute, the trial court didn't sort of separately engage in analysis and make any kind of determination on that front.
I'll agree with that, Your Honor. Yes. As far as the holiday and religious upbringing, the court recognized that holiday schedules, holiday exchanges, given the ongoing conflict, would likely worsen the tensions in the short term and destabilize the children. The plan's modifiable and subject to further review upon the parties' demonstration that they can cooperate. The problem is, if it's a holiday that we know every year falls on December 25th, that's easy. But a lot of these holidays apparently change. They're more like Easter, where they change. It could be any date.
Doesn't the statute, again, I can't tell you which the number is, doesn't it say that the court must divvy up the holidays?
Well, I think in this, Your Honor, that I'm not sure that the court says that it must consider the holidays, but when we're not aware of when the holidays are, I think that might throw a wrench into that.
But you'll know what the lunar calendar says at the beginning of the year, so it's, it's
years
not
ahead.
hard to figure out, right? I mean.
Well, I'm not sure of how hard. It seemed like all I know is that from the testimony.
Are you saying that every Hindu is surprised? Oh, I had no idea today was Diwali. I mean.
There was some testimony.
Surely millions of people are going to know when that holiday falls on in a given year.
I think the question is when did they know, how far in advance they know.
I suspect well in advance.
I think that there was some testimony at trial that showed that they weren't really sure within a reasonable time frame that the court felt that these parties who can't cooperate on anything could work that out. As far as religion, the order strikes an appropriate balance. Neither parent can impose or prohibit religious practices during the other parent's time. This protects the children's autonomy and respects both parents' rights under the First Amendment and Tennessee law. Furthermore, this is consistent with both Tennessee law and the Supreme Court precedent of Wisconsin v. Yoder in balancing the parental rights with the children's rights. The attorney fees award was not punitive, but based on the court's finding that mother's conduct, including her dishonesty, obstruction, and failure to cooperate, unnecessarily increased the litigation costs. Tennessee Code 365-103C gives courts discretion to award fees to the prevailing party to promote fairness, particularly when one parent causes avoidable expense. The appellant's not prevailed on, should the appellant not prevail on appeal, and is not, I believe they have not shown that the trial court erred. In contrast, father has had to defend against unsupported claims. It's essentially asked this court to reweigh the evidence. Therefore, consistent with the prior precedent of Archer v. Archer, this court should award his appellate attorney fees to deter further frivolous appeals and promote judicial economy. In sum, the trial court conducted a thorough and thoughtful evaluation of facts, applied the correct legal standards, and made credibility determinations that are well supported by the record. This case involves the lives and well-being of two children caught in prolonged conflict, and the court's decision appropriately prioritizes their stability and best interests. For these reasons, we respectfully request that this court affirm the trial court judgment and award appellee his reasonable attorney fees and costs incurred in this appeal. Thank you.
Thank you.
Just a few things here. So the comment was made about mom harping on the older child to get her homework done, and that was, according to the older child, a big reason of why she had the attitude she did towards her mom. And I think even my client would admit that she is kind of this overbearing parent that's going to make sure their homework's getting done. And I know that she's like that as a client. Like, she wants things to get done. She wants people to do the right thing. So I don't think that was a good enough excuse to excuse the older child's behavior. I would note, I think this was interesting too, in the final memorandum and order, counseling was ordered between the older child and mom, but not the younger child and mom. So I think that kind of lends to the argument that, well, this child didn't even need counseling, so how can you say that there was a material change significant enough to change custody? As far as if we left the younger child's parenting schedule the exact same as prior to this trial, the practical outcome is the younger child will be spending only 2 days less with the older child on a 14-day basis, really. So they'd still be together pretty much all the time. And frankly, I could see the benefit of the younger child having some one-on-one time with just mom.
Why wouldn't the breakdown of the relationship between mom and the older child in and of itself be a material change of circumstances for the younger child? And if you have your mother and your older sister who are at war with each other in this household, and you've asserted that the older child is essentially putting the younger child in a very difficult position with regard to a number of different things. Isn't that a material change of circumstance? Now, that's separate from the best interest question. I'm not saying, but isn't that a material change of circumstance in and of itself?
I can agree that it is. But even if it is, and you really have to dive into the facts of this case, and you have to look at, is mom the one even causing this material change? Is mom's conduct affecting the younger child so much so that mom needs to spend less time?
Does material change of circumstance have to be a circumstance of blame? I mean, can't it just be a circumstance of need? I mean, maybe mom's not at fault with regard to the material change of circumstance, but it still could be a material change of circumstance in terms of what the child now needs.
For purposes of argument, I'll give you the material change and say that's occurred. But like you said, then you've got to go to the best interests. And I don't see anything in this transcript, which is extraordinarily dense, that reflects that the younger child would be better off spending more intervals of time with dad than mom, or more than she was. So I just don't see it. I see this a lot in these cases where judges kind of just lump the kids together, and I think that's what's been done here.
And here, even if that's done in many cases, this is a different case in terms of there's some clear differences between these two kids and
that their age alone is significant.
So even if that's something that in a typical case maybe shouldn't happen but does happen, are there particular reasons why it's especially problematic here in your view to lump them together?
Well, actually I do. I mean, I've talked about it a lot today. The stuff that this older child has said to the younger child, I mean, she doesn't need to be saying those things. She's around her constantly now, And like I said previously, it would probably be good for the young child to have at least a slight break from that, to have one-on-one time with mom. So, I mean, I think the court should strongly consider that. I know I'm out of time, and I appreciate y'all hearing me today.
Thank you both. Would you call the next case, please?